Hello, am I audible?
Now you are audible. Yes.
Yes, sir. ಶುರು ಮಾಡಬಹುದಲ್ಲ ಸರ್?
ಮಾಡಬಹುದು.
Right, sir. Good morning to one and all. I welcome you to the online national webinar on significance of Human Rights Day, organized by JSS Law College Autonomous Mysore, IQAC and Research Group Organ. To begin with the program, I request our beloved principal, Dr. Nagaraja S, to welcome the gathering.
Hello, Namaskara. Good morning to one and all. JSS Law College, in association with the IQAC and research organ of our Law College, organizing this webinar on human rights on the eve of Human Rights Day. As you know that the entire world is celebrating this 10th December as Human Rights Day. The date was chosen to honor the United Nations General Assembly adoption and proclamation on 10th December 1948. The UNDHR, the first global enunciation of human rights and one of the first major events of United Nations. It's a milestone document that proclaims the inalienable rights which everyone is entitled to as a human being, regardless of race, color, religion, sex, language, etc. And this year's Human Rights Day theme is, it relates to COVID-19 pandemic and focus on the need to build back better by ensuring human rights are central to recovery efforts. On this occasion, I take this opportunity to introduce and welcome the chief guest and the key speaker of the day is our Professor Dr. H.K. Nagaraja sir. A brief introduction about Professor H.K. Nagaraja sir. Professor Dr. H.K. Nagaraja sir is the adjunct faculty at National School of India University. He did his education, basically BSc in the year 1962 from the University of Mysore, and also LLB in the year 1968, and LLM from Bombay University in the year 1972. He did his PhD in the year 1991 from the University of Mysore. Later, he joined as a faculty in our Mysore University in the year 1973 in the Department of Postgraduate Department of Law and Research in Law. Became the reader in the year 1981 and professor in 1992. He was the head of the Department of Law between 1989 to 2001. He was the Dean of Faculty of Law in the University of Mysore from 1991 to 2001. He was my teacher and also the teacher to many of our faculty members of our law college and other the law colleges in our Karnataka. Presently, the adjunct professor of National School from 2006. His area specializations are international law, human rights, private international law. He has published more than 10 papers and he has guided more than 15 PhD students. When we request Professor Dr. H.K. Nagaraja sir to be the chief guest on this occasion, he was kind enough to accept our invitation. Sir, on behalf of JSS Law College staff and students and on my own, I extend a hearty welcome to you, sir.
Thank you.
Also welcome our Professor, Chief Executive, Professor K. Suresh. He is guiding us in all our academic program. I extend a hearty welcome to you, sir. I also extend a warm welcome to all of our faculty members, and the program is coordinated by Mr. A.T. Jagdish and all other staff members, and also all those students who are witnessing this event through online. I extend a warm welcome to one and all. Thank you. So now may I request you to begin your talk. Okay. You, sir.
Now, Professor Suresh and also Principal Nataraj, Jagdish and other members of the faculty in the JSS Law College. You might be knowing that I was also there teaching for a semester for LLM class.
Yes, sir.
Long back before I came to Bangalore. And since then, I mean, it is a great occasion for me also. First, because this is Human Rights Day and I have been given an opportunity to speak on Human Rights Day. And secondly, because that I would be speaking to in the platform and my platform is JSS Law College. Both these things have combined together, and that gives me a great pleasure indeed to speak. You have chosen an appropriate subject, significance of Human Rights Day. Well, the most important thing when I speak about significance of Human Rights Day, as it was already you see, pointed out by the principal Nagaraj, that it was on this day, 10th December, as early as in 1948, the General Assembly of the United Nations Organization adopted in its resolution, you see, on Universal Declaration of Human Rights. It is not as though that the Universal Declaration, I mean, the human rights started since then. It had a history, and there is a future, and also an immense future also, you can see. Now, the significance arises because of the reason that it was already mentioned in the Charter of the United Nations Organization as early as in 1945, when it was established. The Charter, which is the Constitution of the United Nations Organization, had indeed provided for human rights, not only in its preamble, but also in its various provisions. And more importantly, in Article 1 itself, where the purposes and the goals of the United Nations Organization has been mentioned. Now, although I said that there was a past, the language, that is the wording human rights, started then. Earlier, it had a past, it had a history. And we can go back as early as in the Greek civilization itself. But then it was not known as human rights in those days. They might have called it as natural rights, basic rights, fundamental rights, at the domestic level itself. But then there was no such thing as human rights flowing from international law. You see, it was all domestic, it was all in the domestic sphere only. Now, therefore, the significance arises from this day in 1948, when the Universal Declaration of Human Rights adopted, you see, I mean, when the General Assembly adopted in its resolution this Universal Declaration of Human Rights in 1948. But the most important thing to be remembered here is the background for the adoption of the declaration. Earlier, as I pointed out in 1945, in the Charter of the United Nations Organization and in several provisions, human rights were mentioned. But although the term human rights was mentioned, nothing more was there to understand the contents of human rights. They only spoke as human rights, but nobody knew what exactly should be the content of human rights. Now, in order to supplement or to, as a way of complementing that, the Universal Declaration of Human Rights was adopted by the General Assembly. Because at the time when the Charter was Charter mentioned about human rights, it was understood that since it was an obligation imposed upon all members of the United Nations Organization, since the Charter was a treaty, an international treaty, I mean, convention, and it was expected that all states would adhere to the norms of human rights. But then what are all those things to which they should adhere to? That was not known. It was kept uncertain because the Charter did not mention anything about the contents. Therefore, it was left to the General Assembly by adopting this international human rights instrument, which was of great importance. You might be knowing that Eleanor Roosevelt was the chairperson of the drafting committee of the Universal Declaration of Human Rights. There were many, indeed, statesmen who participated in the process of drafting, and ultimately, on this day in 1948, it was adopted. But one thing that we should also know at the same time is that General Assembly, like all other bodies of the United Nations Organization, can only make recommendation. Of course, the Security Council also makes recommendations only, except when it is using its jurisdiction under Chapter 7 of the United Nations Organization, when it finds or makes a determination that the situation or a dispute is a threat to peace, breach of peace, or an act of aggression. Otherwise, what even Security Council would do is only a recommendation. But however much you may call it as recommendation, it has its own implication upon the states. One cannot, you see, disregard a resolution adopted by the General Assembly simply because it is a recommendation. But then it was started that time. Since it was only a recommendation, and many states, as you must be knowing, would require a further legislative process in order to enforce those human rights standards or norms as were laid down in the Universal Declaration of Human Rights. Therefore, what was of importance was that what is the kind of obligation that it is capable of imposing. It was only soft law, a persuasive law, and therefore it was left to the states through its own processes to adopt it so that it becomes law in their own territories. But however, what you notice was it was thought that once the Universal Declaration of Human Rights was adopted by a near unanimous resolution, you see, except Saudi Arabia, you see, nobody protested it. And therefore, it was a near unanimous resolution. Although at that time, in 1948, there were not many states in the sense. The territories in Asia, Africa, Latin America, Caribbean, all those were colonies of the Western countries, whatever it may be. But once a resolution was adopted by the General Assembly, it becomes a recommendation. But the states did not take it seriously. Earlier, it was thought that the human rights norms, as they were expressed in the Universal Declaration of Human Rights, would persuade the states to make suitable laws so that the human rights laws would be made available for the protection of the people all over the world. But that did not happen so. However, what you also notice at that time was there were a number of violations of human rights. I'm not talking the instances of violations of human rights earlier to the formation of the United Nations organization. Because you must be knowing that immediately after the Second World War and also after the establishment of the United Nations organization, Cold War started. With the result, you will notice that the world, although it was not engaged in a kind of a war like the Second World War, the Cold War persisted, causing a lot of tension all over the world. Now, when the instances of violations of human rights started coming to the General Assembly, the General Assembly thought in terms of exercising its jurisdiction for the protection of human rights under the provisions of the Charter, which required the General Assembly, because under the Charter, under Article 10, read with Article 12, you will notice that General Assembly can take up any matter that comes within the scope of the United Nations organization. But however, once the matter was taken up by the General Assembly, the states who were accused of having violated human rights protested the jurisdiction of the General Assembly. Their protest for the exercise of jurisdiction by the General Assembly was based on three provisions of the Charter. Article 2, Clause 1 of the Charter, Article 2, Clause 4 of the Charter, and Article 2, Clause 7 of the Charter. Both Article 2, Clause 1 and Clause 4, you see, insisted upon, or rather required, you see, to respect the sovereignty of the state and also the territorial integrity and political sovereignty of the state. Now, this was the important thing. And paragraph 7 of Article 2, about which I mentioned, you see, it spoke about domestic jurisdiction. And the United Nations Charter under paragraph 7 of Article 2 provided that United Nations shall not intervene in matters which are essentially within the domestic jurisdiction of the state. Now, what entirely fell within the domestic jurisdiction, essentially within the domestic jurisdiction, was important. Now, however, if the General Assembly had succumbed to the arguments, more probably the international human rights law would not have developed to the extent that it has developed today. Because General Assembly, you see, did not yield to the pressures of those states who were accused of having violated human rights. Because General Assembly insisted that paragraph 7 of Article 2 requires an interpretation, and it was only General Assembly which was capable of interpreting it, and its interpretation cannot be done by the states. And in accordance with the interpretation, what General Assembly did was that when paragraph 7 of Article 2 says that United Nations organization shall not intervene in matters which are essentially, there are two terms which requires interpretation. One is United Nations organization shall not intervene. The word intervention has to be interpreted. And secondly, essentially within the domestic jurisdiction. Merely because it falls within the domestic jurisdiction, that would not host to the jurisdiction of the General Assembly. It should be essential, that is, the matter should essentially fall within the domestic jurisdiction of the state. And therefore, if the matter is of international concern, for whatever reason it is, and therefore it is not essentially within the domestic jurisdiction, General Assembly could take up that matter, exercise its jurisdiction. You see, that was how the General Assembly dealt with the instances of violation of human rights during that period. Now, there were a number of such instances, both from the Western countries as well as in Africa, especially I'm talking. So in South Africa, the apartheid policy was a matter of concern because it was a very violent, it was a violation of human rights to a large extent. And the Security Council was not coming to the rescue of the General Assembly, although General Assembly had passed resolutions condemning apartheid policy of South Africa then. However, ultimately, the Security Council was also compelled to exercise its jurisdiction under Chapter 7 because the extent to which the violation of human rights had taken place in South Africa had reached, you see, the matters so that Security Council could exercise its jurisdiction under Chapter 7, which meant threat to peace, breach of peace, or international, or threat to peace, breach of peace, or aggression. You see, under that it took and passed resolution applying sanctions upon South Africa. This is only to point out, if you can go back to the earlier slide, this is only to point out, you see, how General Assembly had its own difficulties with regard to that. Now, please, can you go to the next slide? Now, coming to the United Nations system of protection of human rights. Now, after the, as I pointed out, after the what may be called as Universal Declaration of Human Rights being passed, being adopted by the General Assembly, the question was, how are you going to protect human rights? Because it is only a recommendation. And you know, in international law, there are certain difficulties. The difficulties are not all states would regard a particular international law, including international human rights law, as part of the law of the state. There are a number of states, mostly Commonwealth countries, you can say, including India, UK, United States of America, Sri Lanka, Bangladesh, etc. They would require a further domestic legislation, you see, in order to give effect to those rules of international law. And it happened even in the case of international human rights law, you see. Now, therefore, this difficulty, therefore, the difficulty was, unless there was an obligation upon states, they may not do it. And since the Universal Declaration of Human Rights was only a soft law, laying down only the standards of human rights, it did not legally compel the states to conform to those standards, you see, strictly. Of course, in India at that time, so because the Universal Declaration of Human Rights was adopted in 1948, there was the Constituent Assembly of India, which was drafting a Constitution of India. And therefore, they had the benefit of referring to the Universal Declaration of Human Rights. And that was how Part 3 and Part 4 were carved out. I'm coming to Part 4 also. Now, charter-based protection of human rights and treaty-based protection of human rights are the two streams under the United Nations Organization for the protection of human rights of all people. Now, what exactly is the meaning of charter-based protection and the treaty-based protection? Now, I spoke to you about Universal Declaration of Human Rights, which makes only, you see, which makes only a recommendation. However, there are certain human rights bodies under the charter-based protection which were established. The most important being Commission on Human Rights. In fact, I may tell you that the Commission on Human Rights was established even before the Universal Declaration of Human Rights was adopted. As early as in 1946 itself, the Commission on Human Rights was established, And its main task was to help the United Nations bodies in the protection of human rights. There are also other bodies, like for that matter, Commission on the Status of Women. So there are different bodies under the charter-based protection, but all these bodies can only make a recommendation, and therefore they are only persuasive in effect. But then, as I was pointing out, states were not prepared. Number of states were not making laws, you see, strictly conforming to the standards of human rights as laid down in the Universal Declaration of Human Rights. Now, therefore, it was thought that there was a need for certain international instruments, which, unlike in the case of a Universal Declaration of Human Rights, should be capable of imposing obligation upon states. Now, therefore, they thought in terms of instruments which can impose obligations, and that was how various human rights conventions started. The first and the foremost convention, you see, that is International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights. These were the two important bodies. Now you can go to the next slide. I think these are the two important channels, and now I am coming to the treaty-based protection afterwards. But now coming to charter-based protection, the Commission on Human Rights was there as early as in 1946. I pointed out, but however, in the year 2006, it was wound up, and in its place now, the Human Rights Council is working from 2006 onwards. Now, why it was wound up, that is an important thing about which I want to tell something. The most important reason for winding up the Human Rights Commission in the year 2006 was that although the contribution made by the Commission on Human Rights right from 1946 was immense in nature, you see, it devoted itself to the cause of human rights. Number of developments had taken place. Number of procedures were, you see, adopted by the Commission on Human Rights for the purposes of protection of human rights. Right from the days of, you see, when it dealt with the apartheid policy in South Africa. You see, you will find that the Commission on Human Rights was completely engaged in the task of protecting human rights all over the world. But however, as we reached the millennium, that is from 2000 onwards, you see, the Commission on Human Rights became more a politicized bodies. It was because some of those states who were notoriously known for violation of human rights occupied the membership in the Commission on Human Rights. That was a grave problem, and the United States of America protested, and not only United States, number of states protested. That was how, you see, at that time, the Secretary General of the United Nations Organization, I think it was Kofi Annan at that time, he advised that it should be wound up, and in its place, another body should be created which can completely engage itself in the task of protecting human rights. And that was how, you see, the Commission on Human Rights was wound up, and in its place, Human Rights Council started working from 2006 onwards. The main difference between Commission on Human Rights and the Human Rights Council is Commission on Human Rights is a body that was created by the resolution of the Economic and Social Council, which is one of the primary organs of the United Nations. Economic and Social Council under the Charter has to deal with matters of human rights. That was how it was created. But then now the Human Rights Council is created by a resolution of General Assembly in 2006. As you may be knowing, that compared to Economic and Social Council, General Assembly is a high-profile body, and therefore it gains importance. That is how the Human Rights Council, they thought General Assembly itself should monitor over the activities of Human Rights Council. The Human Rights Council, which was started in 2006 onwards, has made certain changes in its examination of the situation of human rights all over the world. One of the most important, you see, procedures that was adopted was Universal Periodic Review. Universal Periodic Review requires every member of the United Nations Organization has to periodically furnish to the Human Rights Council situation of human rights within its territory. Now, it takes 6 years for the Human Rights Council to examine the periodic reports of all the members of the United Nations organization. Now, now it takes 6 years. Now they have completed the 2 cycles already, and the 3rd cycle is going on. Now, what has to be noted here is that under this universal periodic review, the state has been, the Human Rights Council has examined the situation of human rights all over the world 2 times. You see, it is monitoring over the situation of human rights all over the world for almost from the beginning of 2006, you could say. Now, therefore, it has become a very, very important mechanism adopted by the Human Rights Council for the examination of the situation of human rights prevailing all over the world, because it is concerned with all the members of the United Nations organization. In fact, that is the main distinction between the charter-based protection and the treaty-based protection. Because the charter-based protection works under the auspices of the United Nations organization directly, and therefore it is related to all members of the United Nations organization. And you must be knowing by now, almost all, except 1 state, you see, almost all states have become members of the United Nations organization. Therefore, it has got a worldwide picture now. You see, when you say United Nations, all states, almost all states, you see, are members of the United Nations organization, and therefore under the universal periodic review, the situation of human rights all over the world is being examined by the Human Rights Council. Now, that is one important. There are other procedures also, mechanisms also, which I don't look into, because some of these procedures are being continued, which were already available under the Commission on Human Rights, and therefore they have continued it. Now, coming to the next, treaty-based protection. Please go to the next slide now. Coming to the treaty-based protection. You know, there are different conventions on human rights. Today, we have at least 10 core international human rights conventions. Now, it started with International Covenant on Civil and Political Rights, and also International Covenant on Economic, Social, and Cultural Rights. Now, the most important thing to be remembered here is, originally it was thought of combining these 2, that is civil, political, economic, social, and cultural rights, and to have it as 1 convention. But that did not work. That did not work because the world after the Second World War was a divided world, thanks to Cold War. And therefore, when it was a question of civil and political rights, the socialist states led by USSR were not supporting it, and therefore they would not have become parties to the Civil and Political Rights Covenant. On the other hand, if it is a question of economic, social, and cultural rights covenant, the Western countries were not supporting it, although there was a big support from the socialist states led by USSR. And therefore, Western states might not have become parties. That was the threat. And therefore, in order to avoid such things and to see that as many states as possible would become, you see, parties to these human rights convention, it was divided into 2 conventions. One, International Covenant on Civil and Political Rights, and the other, International Covenant on Economic, Social, and Cultural Rights. Now, coming to this, I can only generally, you see, because I have the time limitation also. What you notice is there are 3 important mechanisms in all these human rights conventions. As I said, we have 10 core human rights conventions, starting from Civil and Political Rights Covenant, Economic, Social, and Rights Covenant, and the other most important thing in the very beginning that started working, even before these 2 started working, was International Convention on the Elimination of Racial Discrimination. Then there was a convention on elimination of discrimination against women, convention on against torture. Then there was also convention on the rights of the child, and so on. Now, in all these conventions, as you look to, there are 3 mechanisms: state reporting, interstate complaint mechanism, and then individual petition, and they're working. So now, what exactly you mean by state reporting, interstate complaint mechanism, and individual petition mechanism? Now, The state reporting would mean, as you look to all these 10 core instruments, human rights treaties, what you notice is that under all these human rights convention, a committee is established. That is the most important thing. Now, the states who are parties to it, that is what you have to know. Because in the case of a charter-based protection, all members of it applies to all members of the United Nations organization. But once you come to treaty-based protection, it is applicable to only those states who are parties to the treaty. You see, for example, if you take Child Rights Convention, about 190 states are parties to it. If you go to Civil and Political Rights Covenant, you see, very first covenant, you will find about 170 states who are parties to it. Therefore, most of the states all over the world, you see, have become parties to the human rights conventions. And under the state reporting, what happens is, periodically, you see, they have to report to the committee under that convention the situation of human rights, you see, under that treaty. Now, situation of human rights would mean how the Constitution is giving protection for protecting human rights, how there are laws for the protection of human rights, how the violations of human rights are dealt with, how the executive and the enforcement mechanism are working for the protection of human rights. You see, these are the main things that will have to be given. Although initially, number of states were not giving the clear picture of situation of human rights. You see, because every state is interested in giving a rosy picture of the situation of human rights. But the committees were not prepared to accept it. The committees wanted an elaborate report. You see, that itself is a big thing about which I cannot enter into the details. But then the committees insisted that an elaborate report was required. Elaborate report means it is not only the provisions of the Constitution, the provisions of the law and the enforcement mechanism, and also independence of the judiciary in dealing with matters of violations of human rights, but also they should come to every article of that convention which gives protection and state what are the protections made available, what are the violations of human rights taken place under that particular article, and how the state dealt with, you see, in the process of protecting human rights. These things should be given. That was how, you see, you will find that the committees were able to clearly examine. Moreover, the committee stipulates a date on which it will examine the report of a particular state, a situation of human rights of a particular state. And on that day, one of the representatives of the state should appear before the committee to brief the report. Thereafterwards, the committee comprising of experts, you see, in the composition of the human rights committees, two things you will note. All of them are experts on the area of human rights, especially with regard to that particular human rights convention. Secondly, it is geographically distributed. You see, there are people from Western European countries, people from socialist states, people from Africa, people from Asian states. Like that, it is divided. Therefore, being experts, you see, everyone, I mean, they will be knowing the situation of human rights prevailing within the territory. And therefore, if a state gives a false picture, there are a number of instances like that when the committee members were able to find out and correct it. Now, that is state reporting mechanism. Secondly, interstate complaint mechanism means when one state violates human rights in a particular convention, another state which is also a party to that human rights convention can complain against that state. But unfortunately, except under the racial discrimination convention, I don't think any state has complained against any other state. Interstate complaint mechanism is not working for this simple reason that every state is a violator of human rights. And if I complain that if one state complains against another state, tomorrow the other state may complain against this state. That is how, you see, you will find, although elaborate provisions are there with regard to interstate complaint mechanism, it is not working except under the racial discrimination. Recently, you see, it has some complaints. Now, individual petition mechanism is a very important thing. But before I go to individual petition mechanism, I should tell you one thing. Under the individual petition mechanism, you see, an individual whose human rights has been violated under a particular human rights convention can directly approach the committee, petitioning to the committee as to how his human rights are violated. But then most important thing is it is optional in all those human rights conventions. Optional means state should have opted for that. But unfortunately, what you find is, you see, India has not opted. Although India, except the Convention Against Torture, is a party to all human rights core convention, it has not opted for individual petition mechanism. Therefore, no individual, you see, in this country whose human rights is violated can approach the committee. But however, there are certain conditions imposed in order to make use of individual petition mechanism. The first condition is that the individual must have exhausted domestic remedies. You see, it is something in international law. You should know the exhaustion of domestic remedies is very, very important. That is, if there are remedies available in that country, he should have exhausted it. But if there are no remedies available, let us say, with regard to that violation of that particular human right, then it need not be exhausted. Or if the remedies available under the domestic remedies is not satisfactory. These are the two exceptions. But however, when making this exception, what is important is that the individual who alleges or who makes a complaint that domestic remedies are not available or not satisfactory, he should substantiate it before the committee. Because when you make use of an exception, you should satisfy the committee as to why you are seeking exception. Another thing is, there are many other things, namely the person whose rights are violated himself must petition. There is no oral hearing. You see, because all these human rights committees are in Geneva, and it wouldn't expect people to go to Geneva. There is only written petition. It only entertains written petition. But on that day, you see, when the human rights, because human rights committees, you see, it is not continuously working. It takes sessions in a year. Some of them may meet twice, some of them may meet 3 times in a year. Now, in each session, it will devote 1 day for entertaining individual petition mechanism. And when it devotes its time for individual petition mechanism, it sits as though it is a court of law. You see, that is how you have to take it. It sits as though, because here, in order that the committee should entertain an individual petition mechanism, what is of importance is that it should sit as a court of law, and therefore evidence becomes very, very important. So a person, you see, first of all, should have exhausted domestic remedies, and more importantly, that state should have opted for individual petition mechanism. And thirdly, what is of importance is he or she whose rights are violated, should himself complain. But there may be exceptions, because so let us say he is imprisoned falsely. State may not allow him to complain, in which case some of his relations can do so, but they have to convince the committee as to why that individual himself cannot do it. There are also other conditions. Other conditions in the sense, evidence is very important. For example, if I complain that torture has taken place, I should produce a medical certificate to that effect, or some such instrument, you see, which would be a proof for torture being committed. And then also you should see that it should not be abusive in language. You see, it should be very specific. You can't go on abusing and try to politicize, you see, this kind of facility given to the individual. So there are certain conditions on the satisfaction of which an individual can make a petition. There are also other procedures. General comment is a very, very important procedure. General comment means each committee, you see, would devote half a day at least in a session for the purpose of general comment. In the case of general comment, what would happen is they will take some provision of that human rights convention and elaborate the meaning of it. That is interpretation to the provision. It is very important because through this general comments, they have been able to develop human rights jurisprudence. Now, inquiries are there. Many times, especially when you take torture convention, for example, convention against torture. You see, sometimes inquiries will, if there is a systematic practice of torture in the territory of state, inquiries will have to be made. And therefore, inquiry is another special procedure which may also be available under certain human rights convention. Now, this is the way in which the entire treaty-based protection works. Now, what you have to notice is that under the treaty-based protection, a lot of changes have taken place. because now they are concentrating more upon, you see, certain issues which are connected to that state. For example, take Chile for that matter, long back. The most important violations of human rights that are taking place were enforced disappearance. That is, especially opposition members. You see, they had to disappear. Nowhere they could be found, which means secretly they would have been killed. Like that, every state, you see, from the reports given already, previous reports, the committee is able to find out what are the specific issues of violations of human rights taken place in the territory. And now, therefore, nowadays, they are insisting that particular state to concentrate upon those issues only and to elaborately give it. Now, after receiving this report under the state reporting mechanism, you see, and then a day is, as I pointed out, a day is fixed for its examination. And then when the representative of the state, you see, makes a report, briefs the report, afterwards, there will be what you called as constructive dialogue. It is called as constructive dialogue in the sense that the questions will be put by the members of the committee to the representative wherever they find there are uncertainties and such other things. Now, therefore, that is how the entire examination takes place. Afterwards, it will give its opinion about it, which will be forwarded to the concerned state and also to the other United Nations bodies like the Economic and Social Council and General Assembly to consider that. That is how the entire treaty-based protection works. I am putting it very, very briefly. It is a very big thing. There are, under the individual petition mechanism, you will find thousands of cases are decided by these human rights committees. But unfortunately, what you have to notice at the same time is these committees also cannot give a decision which will impose obligation upon those state parties to go in accordance with that decision. That is why it is not called as decision, it is called as views of the committees only. But if you take the statistics, what you will find is that most of the opinions or the decisions given by the human rights committees under the individual petition mechanism are, you see, respected by the concerned states. Unless, of course, it is a very sensitive matter touching upon the security of the state or whatever it is. Otherwise, they have been, you see, following the opinions given by these human rights committees. Now, coming to this aspect, namely, nowadays, the human rights committees as well as the Human Rights Council is trying to make, you see, its examination of the situation of human rights more scientific. You see, that is very important. More scientific in this sense, they want information now, not in an abstract forum, but in the statistical forum. Mathematical statistical forum, they want it. For which purpose? They want disaggregated statistical information, which is called as indicators of human rights. Indicators of human rights would mean disaggregated information. And disaggregated information, when I say statistical information, when I say what I mean is, supposing you want to find out whether gender discrimination is there in that territory, by providing, you see, a general average, it would not help. Disaggregated information means you should give information so that the committee will be in a position to know whether there is gender discrimination. For which purpose, you have to find out how many human rights are violated in case of a female and how many violations of human rights violated in the case of male. You see, that will give or throw a light upon, you see, the way in which a discrimination is taking place. This is what is called as disaggregated statistical information. And therefore, nowadays, the international human rights treaty committees are insisting upon, they want, you see, indicators, that is mathematically measured compliance or violations of human rights. That is how it is being now furnished. Now, this is how generally all the international human rights you see, bodies are working. But there are certain limitations upon human rights. This is one important thing that we should note. No human right is absolute. You see, you can't expect. Long back, Kant and others told about it. Namely, you see, I should so exercise my right that it should not invade over the rights of others. Supposing because I have got freedom of speech and expression, I shout at the top of my voice what would happen to the freedom of speech and expression of others in the den of the noise that I have created? Therefore, every human right suffers from certain limitation. You see, this limitation is very important, and it is given in the form of restriction. Even in our constitution, you see, restrictions, reasonable restrictions are laid down. There is also another thing, derogation of human rights. Please go back to earlier slide where I have shown derogation of human rights. Now it is 11:26. How long I can go on? Please tell me. Hello. How many more minutes you will give me now? Can you tell me?
Sir, as you wish, sir.
Pardon?
As you wish, sir.
I will go on for about a few more minutes. Please
Okay,
permit me. Now, derogation of human rights also is an important thing. Now, what exactly you mean by derogation of human rights? As I have already pointed out, generally every right suffers from certain restriction. There is always a restriction upon a right. But then there could be some circumstances where a state may need to exercise more restriction upon the enjoyment of certain human rights than what is available under ordinary circumstances. It may be under three circumstances. Now it is laid down under the International Civil and Political Rights Covenant in Article 4. What it says is, derogation means extraordinary circumstances where you will find under three circumstances, emergency situations may arise. Even India underwent emergency situation. Emergencies for the application of the derogation of human rights would arise under three circumstances. The first is external threat. The other is internal disturbance. And the third is natural calamity. When I say external threat, what I mean is that the threat should be so much that it may affect the very life of that state. And therefore, security of the state becomes very important. Once enjoyment of human rights depends upon the security of the state. If the state itself is not there, where is the enjoyment of human rights? Therefore, under those circumstances, human rights could be imposed with more restriction. The second is internal disturbance. But in a democratic setup, especially, you find there would always be internal disturbance. But that is no occasion for imposing emergency. The internal disturbance should be to such an extent that the state finds it very difficult, and therefore emergency is declared. And the third is, as I pointed out, natural calamity. Natural calamity may be an earthquake of that nature. Now, for example, we have got pandemic, that is COVID-19. You see, that may come under natural calamity, and therefore a state may think in terms of derogation of human rights, that is affecting human rights to a larger extent than what it could do under ordinary circumstances. That is what is called as derogation of human rights. But however, one important thing that you have to notice is that when a state makes a derogation, it is also capable of abusing, you see, under the guise of derogation. You see, it may suppress human rights to a larger extent than what it is required. And that is how you will find under Article 4 of the International Covenant on Civil and Political Rights, certain conditions are applied. The first and foremost is that it should affect to a large extent under these three circumstances only. That is external threat, internal disturbance, natural calamity. The second is that it should proclaim emergency. You see, without proclamation, it cannot do it. And third is that other conditions are applied. That is, when under the emergency situation, a state thinks in terms of, you see, limiting the human rights of the people, then it should have relation to that human rights. For example, you cannot think in terms of, you see, derogating right to life if it is not required for the purposes of that emergency situation. Therefore, it should be relatable to the emergency situation. Like this, there are certain conditions also that are applied on the basis on satisfaction of which only, you see, derogation of human rights can take place. Now, I go to the next thing. Please go to the next slide now. There are a number of criticisms against contemporary human rights. These are the, you see, conceptual level. what are all those criticisms? The first and the foremost criticism is universalism and cultural relativism. Now, universalism means human rights started with this. Even when you look to the Universal Declaration of Human Rights, that certain human rights, as are mentioned there, are applicable to all human beings, and therefore they should all enjoy these human rights. Now, what has happened today is that after the decolonization process was over, you see, from 1960 or even 70 onwards, more and more number of territories in Asia, you see, in Africa, Latin America, and such places, they have become independent states. Now, their main grouse against the existing human rights norms is they are all Western values. You see, there is no place given to the the values or the moral values of the other places. And therefore, they say that universalism is a false concept through which the Western countries, though now they are not imposing political imperialism, they are now imposing cultural imperialism. You see, that is their complaint against it. And therefore, they speak in terms of cultural relativism. Every human right should be perceived, you see, in the context of the cultural situation of that state only. And therefore, the Universal Declaration of Human Rights has failed, according to them, in taking into consideration the values of other side, what they call as we and them. We means Western countries, and them means the others. It is as though the Western countries, you see, have reached what might be called as a perfect civilization, and their culture is the best, and others should follow it. You see, that is how cultural relativism aspect has grown up, especially, for example, when the Vienna Conference of Human Rights was there, some of these Asian countries, you see, they protested, like Singapore, you see, like number of Islamic countries for that matter. They protested. You are not taken into consideration the cultural values of those places. Then there is also feminist, socialist, and post-colonial criticisms. I don't go into that because it is a very big thing. Feminists oppose because they find that the entire human rights system as it is working is from the male perspective only. There is no place for feminine perspective there. And even if you try to give under certain conventions like Convention on the Elimination of Discrimination Against Women certain rights, that is not sufficient, because that is also accorded in accordance with male perspective only. Therefore, that is also not sufficient. Now, the post-colonial criticism also is that same thing. Post-colonial criticism also says the same thing, namely that the way in which the Western countries are looking to the other side is from their perspective. You see, they are not looking at it from the perspective of this colonial situation, and therefore it is not acceptable. Socialist states, they did not, you see, accept it. Even Marx was opposed to these natural rights. Now, criticism on Western dominance on civil and political rights is one thing, because they have given more importance to civil and political rights as against economic, social, and cultural rights. The most important thing is that, especially from the developing and the least developed states, are, you see, poverty is there. Economic development is more important. Therefore, there should be more emphasis on economic, social rights rather than civil and political rights, compared to the violation of human rights that takes place there. For example, in a developed country, if a person enters a mall and steals something, and in a poor country, a person who has no food to eat for the last few days steals a piece of bread, there is a difference between the two. Can you call this person also has violated the human rights? You see, it is what they call as not the violation of human right, but structural violation. That is what they call it. Therefore, the predominance should also be given to economic and social rights rather than insisting upon, you see, only civil and political rights. That's how, you see, the discrimination is also another thing that you notice. You see, in the case of developed and the oppressed states, that is what it has been said, if you look to it. Now, therefore, when you look to the entire structure, you see, what started as something universal, because the voice of the other side was never heard in those days. You see, the entire international arena, as you look to, you see, they were ruled by the Western countries. And therefore, there was not much scope when in 1948, when the Universal Declaration of Human Rights was made, and when certain human rights standards were laid down. Now you will see that different voices are coming up criticizing this kind of a universal, forceful application of the Western values upon all. They oppose it. But that does not mean that there are no universal values. You see, right to life is as important to a person in Western country as it is to a person in other countries also. Therefore, there are identifiable universal values. And therefore, the task should be to recognize those values. Please go to the next slide now, which I am coming to the end of it. Please look to the, yeah. Now, therefore, the entire position could be taken like this. You see, now we have reached a stage whereby we are criticizing the existing norms of human rights. But that doesn't mean human rights are not required. Nobody says today that human rights are not required. Only thing is the way in which certain values are, you see, taken into consideration, which is nothing but Western dominance, what you call as cultural imperialism, as they call it. Now, therefore, Ratna Kapoor, you see, in her famous work, Take a Walk on the Dark Side, what she says is, we cannot not want human rights. We can't just accept it like that. But these are radical tools which we never possessed. And therefore, however much they are flawed, they are with defects, yet there is no option now but to accept these rights, because something is better than, you see, nothing. That is how it is. Now, therefore, when we think in terms of human rights, what we should note is they are not simple, a simple development. You will find lots of things have happened. So much criticism is there, critical way of looking at it. All these things have to be taken into consideration. And therefore, I thought that on this day, you see, when about 70 years back or so, when the General Assembly adopted in its resolution Universal Declaration of Human Rights, you see, we could look back and find out what exactly the development that has taken place. It is not as simple as it is what thought to be when Universal Declaration of Human Rights was adopted by the General Assembly. So much development has taken place. I'm only pointing out that if you look to individual petition mechanism today, of course, India has not opted for that, but still, you see, for example, Sri Lanka has opted for that. Nepal has opted for that. Thousands and thousands of cases are decided by the committees, international human rights committees, various bodies. And as you look to it, what you notice is that we have moved forward, no doubt. Not that we have reached the goal. It is a process where we have to, where we should continue to move. You see, there is no such thing as putting an end to it, because human rights is perpetually developing, and we should follow that. And with this, I will be ending up my lecture. I take this opportunity to thank the organizers of the JSS Law College for having given me this opportunity to speak on human rights, which is a subject I have been, which is a subject on which you see, I have been lecturing for the last almost 15 years in the National Law School, and you have given now today an opportunity to look into that in a very brief manner, of course, here also. Thank you so much, all of you. Thank you.
Thank you, sir. Very nice presentation, and also very resourceful one. And now I request our students, if there are any questions, very specific questions, you can post the question through chat box.
If there are any questions, and if it is possible for me to address those.
No, sir.
Okay.
Any specific questions, you make your questions very precise. Okay. Yes.
You can unmute and speak.
Yes, students can unmute and speak. Before going to the students, just I have one clarification, sir. See, to what extent this human rights and its values are respected in, especially the Muslim countries, by referring to the Islam of Afghanistan and the Pakistan and other Muslim countries.
I understand that question. you know that what happens is we have got human rights conventions, as I said, but there are certain conventions on which Islamic countries have their own reservations. Especially, I am referring to two conventions. There is International Convention on the Elimination of Discrimination Against Women and International Convention on the Rights of Child. Because in the rights of the child, you see, the question is about freedom of religion is given, which is not accepted. And in the case of elimination of the discrimination against women, you see, the problem is there. But number of Islamic countries are parties to it. But then you can ask me how it is so. The only thing is, in international law, when a treaty is there, it imposes obligation upon the states. But the states also have the benefit of making reservations to the treaty. Making reservations to treaties means that a state which becomes a party to the human rights with reservation can seek exception from the application of a few provisions. Now, what most of the Islamic countries have done with regard to, say, for that matter, Convention on the Elimination of Discrimination Against Women, what they have done is their exception, they have made it with reservation, saying that so long as it is in conformity with Sharia law, you see, that is how they have put it. You see, so they accept discrimination against women, and with reservation that if it is not, if it is only in consonance with Sharia law, that is how they have put. Whether it is right is a different question. I can't speak about it. Yeah. I can only say that with reservation they are accepted, and accordingly they have conformed to those things. It is allowed in international law, and I cannot go into the details of the international treaty area, because reservations to treaties are acceptable only when it is in consonance with the object and purpose of the treaty. That is what international says. But in the human rights area, you see, it is something else, because under the what may be called as in the light of decision of the International Court of Justice, decided long back, that is reservations to genocide convention, you see, some other principle has been there. Namely, the purpose of all human rights treaties is to see that as many states as possible become parties to the human rights conventions. So they have applied that. And therefore, if you strictly say you cannot make exception, they will not be parties. And therefore, to see that they become parties, afterwards you try to convince them. And that is what, you see, human rights committees have been doing it. They have been persuading states to withdraw their reservation. Some of them have done it, but many of them have not done it. That is a different thing. But it is a process undergoing. Yes.
Thank you, sir. Thank you, sir. Any questions from student side? Yes, please unmute. Who's that? Some Muhammad. Hello.
Yes.
Your questions should be very specific and clear. Yes. Or you can send your questions to chat box. No questions?
Pardon, please repeat.
Yes, anybody?
Hello?
Yes, sir.
Yeah.
Sir, the second question is, are countries bound to take any special measures in the view of COVID-19, as you claim that there can be a derogation of human rights in case of a natural calamity? Can COVID-19 be considered to be a natural calamity?
No, that's what I was telling you. Some states have done it. In fact, some states have done it. And on that basis, some of the human rights, for example, right to association. See, for example, you see, because that is how you see in the when COVID-19 is there, social distancing is practiced. That, you see, violates the right to association, is it or not? So because of that emergency situation, it is permitted. They have declared like that. Some states have done it.
Right.
Yes.
Now, before concluding this program, I request our colleague Mr. Jagdish to propose formal vote of thanks.
Sir, it gives me an immense pleasure to propose this vote of thanks. I express my heartfelt gratitude to Professor Dr. H.K. Nagaraja, sir, Adjunct Faculty, National Law School of India, University, Bengaluru, for accepting our invitation and delivering a very valuable, informative session on the significance of Human Rights Day. I wholeheartedly once again thank on behalf of JSS Law College Autonomous, entire faculty and students on behalf of entire students who are present here, sir. Thank you, sir.
Thank you very much. Thank you. Thank you.
Also, I would like to extend my special thanks to Professor K.S. Suresh, Chief Executive, who has been the backbone of all our activities and endeavors. Also, I thank Dr. S. Nagaraja, sir, Principal, JSS Law College, for his presence here. I thank Mr. Madhukumar for the technical assistance rendered. Thank you, sir. Also, last but not the least, I thank all the teaching, non-teaching staff and the students of the college and participants from outside who have gathered in this online national webinar on significance of Human Rights Day. Thank you one and all.
Sir, ತುಂಬಾ thanks, sir. ಧನ್ಯವಾದಗಳು. Hello, sir. Thank you so much, sir.
Thank you.
Yes.
Thank you.
ಕೇಳಿಸ್ತಾ ಇದೆಯಲ್ಲ ಸರ್? ತುಂಬಾ thanks, sir. Thank you, sir.
Thank you.
Okay, sir.
Okay. Thank you.
Thank you.
Thank you.
So kindly fill the feedback form.
I will take leave now. Okay.
Thank you, sir.
Thank you, sir.
Thank you, sir.
Thank you. Thank you.